Florida law has some common misconceptions, and I'm going to cover four of them, the four kind of biggest ones that I hear sometimes and you see repeated on the internet or in person. I don't want people to be fooled by the information that they hear, so I'm going to try to clear that up. The first thing is arrest always leads to conviction. This is not correct. Conviction requires a plea or a trial. You are entitled to due process. DUI, having to do with DUI refusal. And the most common myth about that is a DUI refusal to blow means you can't be convicted of DUI. I'm going to go into that. The blood alcohol content is just one method of proving impairment. So the third common myth is stand your ground has to do with Florida's stand your ground law, which is a self-defense law. That means you can always use deadly force. That is not correct. You have to believe you're in imminent danger of serious harm or death, and it has to be proportional. And lastly, the fourth myth is that you have to speak to the police or answer their questions. That is also not correct. You have the right to remain silent. Myth number one, an arrest means you're guilty. That is not correct. Let's start with this one. Just because you've been arrested doesn't mean you'll be convicted. So, under the U.S. Constitution, the Fifth and Sixth Amendments of the U.S. Constitution, and also the Florida Constitution, some people don't know that Florida has its own constitution as well. Florida Constitution, Article 1, Section 9, you have the right to due process. So, what that means is, in this context, is a conviction only occurs after a plea, a plea, that's like a plea of guilty or no contest, voluntarily entered, or after a trial where the state has to prove you guilty beyond to the exclusion of every reasonable doubt. So the trial can be a jury trial or a bench trial, but they needs going to be one of those things are going to be necessary to have a conviction on your record. Being arrested is merely the beginning of a criminal process, not the end. So that's the two things shouldn't be conflated. You still have rights, and we're here to defend them every step of the way. That would be my role as a defense attorney. So that's the first myth I want to kind of address and make sure everybody's really clear on that. Myth number two, refusing a breath test, and that has involving DUI. Refusing a breath test means you can't be convicted of DUI. So this is a myth. Many people think refusing a breath test has that effect, but that's not correct. Uh, just because you've refused a breath test doesn't mean you can't be found guilty of DUI. That is simply false. Under Florida statute 316.193, a person, that's the DUI statute, a person can be convicted of DUI if they are in actual physical control of a vehicle